Swayam Prabha. Digital India. Educated India.
Penalties. The patent law has certain penalties if there are certain violations under the Patents Act. Infringement is not a criminal act. The Patents Act does not make infringement, patent infringement, an act that can be visited with criminal consequences. Whereas under the Copyright Act, copyright infringement can have certain criminal implications. You could be tried in the criminal court and there could be punishment which could amount to imprisonment. Now, we don't have that provision in Patents Act. A patent infringement is not a criminal offense. It has not been made into a criminal offense, unlike copyright infringement. Now, 118 talks about the contravention of secrecy provisions. We have seen already that there are certain secrecy provisions which could be issued, and a direction, if it is issued, if it is not complied with, or a person contravenes section 39, that is where he needs to take prior permission before filing an application abroad, he shall be punishable with imprisonment for a term which may extend to 2 years, or fine, or both. So there is criminal consequences in the form of imprisonment that can come in case of section 35, non-compliance with section 35 and contravention of section 39. Now, 119 talks about falsification of entries in the register. Again, that's something that is punishable with imprisonment. 120 talks about unauthorized claims of patent right. That is, if a person falsely represent an article sold by him to be patented in India or is a subject of a patent application, then that is misrepresentation. So that can be punishable with fine which may extend up to 1 lakh rupees. So this offence is punishable only with fine. There is no imprisonment to this provision. Then wrongful use of the word patent office can be punishable with imprisonment for a term which may extend up to 6 months, or fine, or with both. Refusal to supply information. Now, there are provisions where a person can be obligated to supply information, section 100 subsection 5 and section 146. In such cases, the person may be punishable with a fine that may extend up to 10 lakhs. And if he fails to furnish such information, or he furnishes information or statement which is false, then he shall be punishable with infringement which may extend up to 6 months. So the information that is being sought for in 122(1), if that turns out to be false, then there could be punishment. So here is a provision where there is an initial fine, and if the information that is being provided turns out to be false, then there could be imprisonment. 123 talks about the practice of non-registered patent agents. Patent agents are the only professionals who can practice before the patent office. Any contravention of the provisions under section 129 shall be punishable with 1 lakh rupees for the first offence and 5 lakhs for the second and subsequent offence. So patent agents, if someone pretends to be a patent agent or acts as a patent agent without being one, without clearing the exam and being registered as a patent agent, there could be a fine of 1 lakh rupees for the first offence and a fine of 5 lakh rupees in the second and subsequent offence. There is again no infringement in this case. Now, offences by company, the normal course is that the person who is responsible for the conduct of its business will be deemed guilty of the offence. Now, what amounts to a company? It means any body, corporate, firm, partner and director, all these things are given in the explanation.